Hello, ladies and gentlemen, and welcome to yet another edition of Focus on Liberia. This is the FOL Justice Forum, where we discuss the court, the law, the legal system, and its impact on the Liberian people and their fundamental rights. Tonight is the third edition of the Court of Liberia, and we're going to be looking at the Supreme Court of Liberia, the structure and the functions of the Supreme Court. We've been doing this for a while now. We are so glad, we are excited, we are elated to have Attorney Moriah Yeakula join us tonight. Moriah, welcome to Focus on Liberia FOL Justice Forum.
Thank you. Thanks for having me.
We are glad to have you. Also joining us is Councillor Jerome Verdier. Councillor, welcome to Focus on Liberia.
Thank you, Mr. Host. It's a pleasure to be here to join my colleagues for what promises to be a fruitful discussion on the legal process in Liberia.
That is very important. Next, we are joined by Councillor Frederick Jayweh, who's joining us from Denver, Colorado. Councillor Jayweh, welcome to Focus on Liberia.
Thank you very much, Dennis. I'm happy to be here. I always say that this is a very important topic, and the discussion has been very fruitful. I will hope that our people can pay key attention to ensure that they understand what the rights are and the impact of the law on those rights.
Thank you very much. And Councillor Verdier, if there's a way you can turn your phone sideways or in a horizontal or landscape position, so we can have to do that.
Pushing on the side a little bit.
Yeah. You should turn it sideways like this and put that in rotate mode so we can have a better picture.
Okay.
Yeah, if you do that, you should put that in the rotate mode so that you're able to rotate.
Amen.
All right. Let's keep it at that if you can do it.
Is it okay, or I should still change position?
No, if you have it in a horizontal position, then you have to go in the settings and put it in the rotate mode.
Okay.
All right.
I'll work on it.
So work on that, and we'll be with you short. All right. So let's start our discussion. So, Attorney Moriah, this is your first time. I don't know if you had an opportunity to watch this before, but I just want to get your opening comments on the importance of talking about our legal system. Most of the time when we talk, it's political, and then we don't have the kind of legal advice to tell us that, hey, this is wrong or this is right. So we've started this show to be able to at least educate the public on these legal issues, and we're glad to have you again. Welcome.
Thank you, and I'm really honored to be here with my senior counsels. As you would note, I'm still an attorney, and they're all counselors. So there's, of course, they're my senior counsels. But I'm happy to be here. I am definitely excited about this conversation because I think, one of the issues we have in our country today is the rule of law and access to justice. And in some way connected to that is the perception around the judicial system, around our court system, the lack of trust in our judiciary and our court system. So I think having these conversations will help either clear some doubts, will help people understand how the system works. And I'm just glad we're here to have that conversation.
Thank you. And Councillor, this is part 3 of the series on the courts. We talk about the criminal courts, the civil courts. We talk about the specialized courts. You were here last week. Just give a brief summary of the specialized court as we discussed last week.
So last week, we dealt basically with the probate court, its function, its structure, and what I expected from attorneys or party litigants as they appeared before the probate court. We also went down to speak a little bit about the labor code. And what goes on there, what matters that are cognizable before the labor court. And we spoke a little bit about the commercial code, the tax code, the juvenile code, and the traffic code and the debt code. They are referred to as specialized codes because matters that might go before the civil law code A and B, like action on debt. Civil law code will not directly entertain a debt action unless it might have grown out of either an ejectment suit or a summary proceeding to court possession of real property, something like that. And labor cases, they are employment related. They will not go to the civil law court. So they are specifically given tax that will be specialized, And so they are not, though they maintain the same structure and status as the civil law code and any other Saki code in Liberia, but their duties and responsibilities are very special. For example, if you bought land any part of Liberia and you want to ensure that you follow and complete the legal process, you go to the probate court. You will not go to the labor court, or you will not go to the civil law court or any of the criminal court. So the clarity that we made during our last sitting was to ensure that people know that if somebody owes you money, you go to the debt court if the amount of money is above the trial jurisdiction of the magistrate court. If you work for Firestone, for example, and Firestone doesn't pay you, or you are retired outside of you are dismissed outside your retirement time frame, is a labor matter. You can go to the labor court. If you have anything that had to do with business transaction, bank to bank, loans from banks and whatnot, it's a commercial matter. And the traffic code dealing with vehicle and traffic laws to ensure that if you have accident, somebody may accident hit your vehicle, you don't go to the probate court. The essence was to ensure that people understand the function and the different types of courts that Liberia has, so that when you hear that in action before the debt court, you will not be surprised that someone has filed a lawsuit against you before the debt court.
Thank you. That's a summary of what we went through last week, and so thank you, Councillor. Now we have Councillor Verdier back. Councillor, we'll manage with what you got.
Okay.
So every day before we start, the topic for today is on the Supreme Court, and this is just part one of the Supreme Court. We're going to go to part two. We'll manage with what you got. So we'll go to part two of the Supreme Court, but part one of the Supreme Court will deal with the structure and the function. But before we start that, we always look at any trending court issue that we want to talk about, and which one is trending more than the one involving the ANC political leader, Mr. Alexander B. Cummings. And Counsel and Attorney Moriah, you can correct me where I'm missing it, but what happened is at some point, the evidence that was presented it was, I think, after the discovery process, that text messages from the conversation of the CPP, the hierarchy, was presented in court. And the lawyers representing Mr. Cummings said, wait a minute, this is not all the documents, something is missing here. And so we heard, it's reported in the papers, that yes, indeed, those that were going to prove that Mr. Cummings is innocent of those things that he's being charged with were omitted, were intentionally omitted from the text messages that were presented or from the documents that were presented. So at a stand, I want to understand for all, what is the implication if the lawyers knowingly omitted documents that they felt were favorable to the one being prosecuted. What does that say, and where does it go? Councillor Verdier, let me start with you. I know Anthony Yeakula will be last on this one.
Well, thank you. And I heard you speak of lawyers omitting documents. I haven't been following the details of the case, but I'm aware of the issues. In court, some evidence are circumstantial and some are substantial. Some evidence may be germane to the case, some evidence may not be. Omission of evidence in a prosecution or a criminal case, or even a civil case for that matter, is an offense to the judicial process. The purpose of justice or the criminal justice system is not just to prosecute people, find them guilty, and send them to jail. The major objective, in my estimation, is to arrive at the truth. Because most of the time you have two people contesting on a particular issue or a situation, and you need the neutral arbiter to help people arrive at what the truth is. The Bible says, by the testimony of two, more than one, a judge should be in the position to determine what the situation is. So when you involve in a legal battle, you want to arrive at the truth. And there are rules and procedures on how to do it, so that the person who wasn't present, like the independent or neutral judge, can be in a position to make decisions. So in arriving at the truth, you want to make sure that the innocent person will be set free and the guilty person will be held accountable. So if you manipulate evidence, okay, that will either favor the defendant or the opposing party, that is an act of injustice, and in most jurisdictions, it's a crime, even for the prosecutor or an attorney involved in the prosecution of the case. Even if it's not a crime, it's a violation of your judicial ethics and the principles we all stand by. So I don't know the nitty-gritty of what was left out, but listening to you, somebody withheld evidence that could exonerate Honorable Cummings. And if that was done, it's wrong. And both parties, the prosecution and the defense, have a responsibility to superintend their case, to supervise their case, to make sure that all the evidence that is needed is provided before the court, which is the neutral arbiter, so that there can be no prejudicial, interpretation of what is happening in the court. So if that was done, I think it was wrong. And we could have a mistrial or a miscarriage of justice if the defendant is denied the opportunity that such material evidence, if the evidence material, can be brought before the judge.
Dennis, I know I'll be last, but can I just provide maybe the information, and I'll keep my opinions to myself until it's my turn, but so that they can have that.
Yeah, go ahead.
Okay, so basically, part of the allegations against the defendant, Mr. Cummings, is that he altered the framework document and his colleagues were not aware that he did that because he did not submit the final framework document to all of them, and that they did not sign the final framework document. And it was later on, after the CPP was formed, that they realized, someone notified them from NEC that the framework document was different. And so basically they're accusing him of not having informed them or notified them or giving them a copy of the final framework document because he altered something in the document. A part of the messages that was submitted was a discussion between July 7th to July 9th that shows Mr. Cummings submitting the final framework document to all of the parties and informing them that their signatures will be collected in order to file the document at the NEC. Part of that conversation also shows the ALP chairman who actually brought the suit against Mr. Cummings, asking Mr. Cummings if the chairpersons of the parties will be signing too, which Mr. Cummings confirmed and said yes. So, given that the document, the conversation showed that he submitted a document on between July 7th to July 9th, and the document was filed July 14th, the prosecution excluded that portion of the chat room text messages from the evidence before they submitted into discovery. And that is what the defense later realized, that the evidence submitted had excluded and extracted that critical portion that showed Mr. Cummings submitting the final framework document to the CPP and letting them know that the signatures would be needed for the document. And so they filed a complaint for prosecutorial misconduct. And that complaint was heard by the judge or investigated. And last week, one of the prosecutors from the Ministry of Justice conceded and admitted to the judge that yes, that portion of the text messages were inadvertently removed from the evidence. And so they asked the judge to admit that portion into evidence, which was done. But I just wanted to provide that background.
Thank you. So, Councillor Jayweh, here is the thing. So, and that is correct. That what happened, as we read in the papers, that a key evidence to prove Mr. Cummings' innocent was omitted by the prosecution. And on Wednesday, the Solicitor General's team admitted to the court that there were omitted pages from the evidence, but such was done inadvertently in error. The omitted pages were then submitted to the court. Councillor Jayweh, what happened here now? So if they admit, do they first have to prove that this was criminal, or it was done with an intent to hide evidence? Would that be a crime?
So it is a trial judge. Let's go back a little bit. This matter is before a magistrate. The magistrate in Liberia will sit both as a trial of the fact and also the pass on the laws. Considering the complaint that was filed by Mr. Cummings' lawyers, the magistrate heard, investigated, and by the facts, I understand that one of the prosecutors came to court and admitted that indeed there was some documentation extracted. And so, but it was inadvertent. That's what they said.
That's a mistake.
So the question is, what would the court do next? If the court did not do anything after receiving the portion of the documents that were allegedly extracted and proven to be extracted, and allow it to be admitted into evidence without doing anything else, that's what will happen. Nothing else will happen. If the judge wanted to establish or punish the prosecution team for extracting the documents, then the issue would have been that either they would have been forwarded to the Grievance and Ethics Committee for further investigation. Perhaps some of their licenses could be suspended if they did it with the interest of ensuring that the portion of the document that were extracted will not be used to exonerate Mr. Cummings. Now, I need to add here, the case is not at its conclusion, it has not ended. So in order to give probative value or weight to the entire evidence produced during trial, the magistrate will have to examine all of what has been said. And I don't want to take judicial notice of what is written in the press. It doesn't make sense to me because the press, people writing in the press are journalists and not lawyers. Meaning that whether the extracted document that will return, whether it could be used to exonerate Mr. Cummings, would be what the judge would do at the end of the day when he review both the document from the state and the document from the defense counsel representing Mr. Cummings. So we yet have to see whether or not the document that being referred to in the press had that much probative value, consistent with whether or not the case should be dismissed, and that Mr. Cummings did not forge any document. It is in total, so there's no jury in this case. I mean, there's no jury attached to this court. So the judge will have to sit and review all of the document. I would not say that it is enough to say that this document can exonerate Mr. Cummings or can convict him. What I would say is that, and what I said the last time was that, as a trial lawyer, as a defense lawyer, you are under real responsibility to ensure that your client is defended. You don't give excuses, because it doesn't matter how many pages that you have to read through before you go to court. You must ensure that no trick is played on you. You must ensure that no documents are extracted. You must ensure that when the documents are submitted to the witness to be identified, mark, confirm, and reconfirm, your objection should be at that time. You cannot wait until the documents are identified, they are marked, they are confirmed, and reconfirmed. You run into real legal trouble when that happens. Right. In this case, it was because the document was extracted. If Mr. Cummings would be convicted or not convicted would depend upon the summary of all of the evidence that the court has before it.
Right. And Mr. Councillor Jayweh, without going into the merit of the case, okay, so I want to give you a what-if scenario. So the case here is Mr. Cummings did change the documents without the knowledge of his colleagues. And so that piece of evidence that proved that whatever changes were done was to the knowledge of the other parties. And that was the evidence that was removed. Assuming that's the case, will the prosecutors be punished? Will the case be dismissed? Will they be charged criminally? They say, well, this is their intent. You intended to do this to deceive us. So in fact, we're throwing out the case. Would that be the case, hypothetically?
So if the magistrate, after reviewing the volume of evidence before him, finds that the evidence drives the idea that Mr. Cummings should be acquitted, then he will be acquitted. And that will be the end of it. Perhaps the prosecution may decide to appeal to Criminal Code A to review the appeal if they think merit is in why there is merit in appealing the judgment. Now, when a lawyer, let's say the state, if the state in this case should lose this case, it's not a ground for punishment unless the government, unless the court can investigate and find that ethical breaches, intentional ethical breaches occurred during the trial. In the absence of that, the prosecution would just be losing a case. That's one of those. It would be one of those cases that the state would have lost. Again, if the judge wanted to go further than that, he would have ensured that the prosecution would not just say, you know, we left the evidence, pieces of evidence out by mistake, inadvertent. He would have said, no, this appeared that this is a breach, and he would have also sought to ensure that they were punished. He did not do that, so I don't think he would do it. Or he could do that if he wanted to at the end of the case, if he wanted to pass on it. But there's not an issue that is before the court any longer. So if Mr. Cummings should be acquitted, that could be the end of the case if the state did not announce a appeal and follow up. An appeal from the magistrate court, within 15 days, the record should be copied and taken over to Criminal Code A for the case to be reheard if there is an appeal.
Thank you. Attorney Yeakula, is this criminal? You're muted, Raya.
I believe it's borderline unethical, and I'll have to check the penal code on whether it's criminal. It does appear criminal, but in terms of your judicial ethics as a lawyer, it is clearly a violation of our ethics code as lawyers. And Councillor Verdier said that succinctly earlier, that the role of prosecution is not to convict; it's to ensure that justice is done and that the truth is revealed. And so, to give the trial of facts, the opportunity to come up with an objective judgment. And so, for prosecution to intentionally, I would say, extract evidence that speaks directly to the allegations against the defendant is intentional. Why weren't there other evidence that were inadvertently extracted? And of course, there's evidence that's circumstantial, that's not really important to the case. And there's evidence that speaks to the core of the case, very substantial. And this evidence particularly speaks to the allegations, like you said, that he altered the document without the knowledge of his colleagues, and that's why he didn't submit it to them and went ahead and filed it on neck. That's what they're saying. We're not aware of this clause in the document. We didn't see the final document. He didn't submit it to us. And then there is evidence that shows that he submitted it to you like a week before it was filed on neck. And the prosecution decided that of all of the mistakes they could make was the mistake to remove that portion of the evidence. And just for context, this is a chat room that went over 2 years, from 2019 to 2021, maybe early 2022. So 2 years of conversation from May 2020 to 2022. 2 years of conversation in the chat room with all of the political leaders, so for those listening, the NSC chat room, the National Advisory Council chat room, is the highest decision body of the CPP outside of the National Assembly. That body comprises of all the political leaders, all of the party chairpersons, and so each party sends 5 persons each to the advisory council, including the political leaders and the party chairpersons and 3 other persons. So 5 times 4, 20 persons in that chat room, all leaders of the CPP. That's where they communicated. That's where they share documents. That's where they share meeting minutes. That's where they discuss CPP issues. So 2 years of conversation around CPP. And the only conversation that was mistakenly removed from the evidence was the conversation that speaks directly to the allegations, that shows that the allegations are bogus and are not truthful, that he did in fact submit the final copy of the framework document to all of the parties. And the prosecution wants us to believe that it was done inadvertently. Now, let me explain to you why that doesn't make sense to me or to anybody who has any knowledge about how WhatsApp works. It is not something that you can go and add and subtract. It is when you export a WhatsApp chat, it comes as a transcript with all of the messages. You have to go back into that transcript and delete specifics that you don't want in that transcript. I see Councillor Verdier laughing. It's an intentional act. You have to go back into the transcript. So imagine 2 years of conversation from a chat room. You go back into it, and the only ones that are not part of the evidence from that chat, because you submitted the chat room as evidence. As a matter of fact, the chat room was submitted to prove that Mr. Cummings did not submit the document.
Right.
That's
So
why they submitted the chat room.
Attorney Yeakula, in this case, how? Sorry. In this case, how can you prove intent? To say, well, they intended to do this, they intended to mislead. How can the court prove that?
That's a good question. So other senior counsels can come in, but again, it goes back to what I was talking about. Of all of the messages from the 2 years of conversation in the chat room, is it only the portion of the
Yeah.
messages that speaks directly to the allegations that was mistakenly removed? And also intent speaks to not just the intent of, purposely doing it, it's the how it was done. If you have to go through messages and delete messages out of the transcript, then it was intentional, because that requires you taking time. That requires it requires a mens rea. It requires like an intentional thought about
Right.
sitting there, opening up the chat, the transcript of the chat room, and going through 2 years of chat messages to find a part of the chat messages that does not support your case,
Yeah.
and then remove it. That's the intent. That's how you prove intention. That's how you prove that it was intentionally removed. Because when you export a WhatsApp chat room, all the message, in fact, there are two ways you can export it. You either export it with the media, or you export it without media. The media is the videos, audio messages,
Right.
documents, and everything that's in the chat room. So if you export, the only time you will not have those things attached is when you export without media. But even without media, the messages are exported. It's only the attachments that's not.
Okay.
So for anybody to say that it was mistakenly omitted or it was mistakenly extracted, it doesn't make sense for people who know how WhatsApp works, because that means the transcript of the WhatsApp chat room, somebody sat down and decided to go through 2 years of WhatsApp messages and remove the portion that specifically did not support the case against Mr. Cummings.
Okay. Thank you. Councillor Verdier, we are human beings. I'm saying to you, I made a mistake. I mean, what else can you, what can you do about that?
Well, you see, as I was laughing, I was agreeing with.
I saw you laughing. That's why.
Yeah, because I am an ardent user of WhatsApp. It doesn't work that way. It requires deliberate effort to exclude that body of evidence from the transcript that was submitted. Now I'm imagining how it happened. I think it was probably printed, and somebody took that part out of and made sure that the printed version doesn't carry that part. It has to be deliberate. It has to be intentional, and that's the kind of transgression that's the profession forbids. And depending on the substantial nature of what he has done, the judge will be in a position to announce sanctions. And in that case, it could be anything from fine to suspension, which means we have to go to the Supreme Court, depending on how material the parties take the transgression or the violations to be. But it's highly unethical, it is wrong, and in my mind, it's criminal in nature, because you are falsifying evidence. And it goes to the point of trying to perjure the process so that things can go your way. That's a dangerous act, and I hope they can go through it. And without biases, allow the judge to do what he has to do. And there's one thing that came to my mind, and the thing that bothered me about this case that I didn't focus on is whether the case is at the ministerial level on preliminary examination or it is a trial.
It's a trial.
It's a trial at the magistrate level. It's a misdemeanor.
Oh, okay. Okay. Then I get it clear. I was confused about it, and I just stopped paying attention to the case because I thought we were wasting time.
No, I think they amended the forgery, the act that described forgery in the code. It could, because if you went by the penal code, forgery could be it's a second degree felony. It could be a first degree misdemeanor.
Yes.
Second degree felony is 5 years. If you're talking about a misdemeanor, it would be like 1 year. I think I got confused a little bit, but later on I found out that the act has been amended to treat forgery. I don't know who advised that. I wouldn't have advised that because forgery will at some point require dual proceeding because you're talking about fraud, you're talking about other things. That would be material enough that I don't know how they amended that act and who advised that, but I didn't believe the case would be before the magistrate court. I thought by now the circuit court would be handling it, but I think the statute.
I think that the way they amended the statute, they have forgery for government records, forgery for, so most of the forgery that has to do with government workers, I think, and stuff, it's first degree, is the felony, and then they said any other forgery, so I think the last portion of the law, it says it's a misdemeanor. So that's why it's at the magisterial court. And it's interesting that we have the Solicitor General prosecuting a misdemeanor at the magistrate level.
That's where part of the confusion came from. The Solicitor General himself to lead the prosecution. I was wondering what's going on. And then I just eventually gave up interest. Yeah.
I wanted to add with Dennis.
Yeah, and just conclude on that when you add, where do we go from here? What next?
Well, what I thought would happen if the magistrate should be doing is that since the issue is bordering on the extraction of the documentation that the state came back and said was done by mistake, and the issue is whether or not Mr. Cummings actually contacted Yeakula Kanga, contacted Dr. Joseph Boakai with all of the finalization of the document before they were filed at NEC. Either the prosecution, the judge, or the defense can subpoena Mr. Boakai to come to court and testify in order to be able to have real facts as to what really went wrong. Mr. Boakai should be able to come to court. Yeakula Kanga should be able to come to court. Whether they are witnesses or not, I will request the court to grant a subpoena to bring them to court to testify in order to clarify whether they are actually informed or do they know of the finalization of the CPP document before it was sent to NEC. And I mean, it could be done by other party. It could be done by the state on a direct. It could be done by the prosecution, the defense, by requesting that a subpoena be served on them. It could be done, the court on its own could subpoena the three people to come to court before it enters a judgment. I don't know what the magistrate would do, but that would be the appropriate thing to do.
So from what I understand, the prosecution has listed Ambassador Boakai, Madam Yeakula Kanga Lawrence as subpoena witnesses. I'm not sure how far that has gone, but I know Serena Sivas has also said it publicly on radio shows that those were going to be his witnesses. But I think also on the issue of whether they were aware, it's almost like the way we have our chat room. If it's the regular course of business to submit documents and meeting minutes and conversations around the running of the organization to the chat room, it is assumed that when documents are posted in the chat room, you will see it. You have a responsibility to notify, and note that. And I should also say, though, that when that document was posted, they all responded, thank you. When the information was sent about collecting the signatures, they said, thank you, Mr. Chairman. Thank you, Mr. Chairman. Thank you, Mr. Chair. So they all acknowledged receipt of he's laughing. So they all acknowledged receipt of his message and of the final framework document. So it's there in the chat room. You can see from the transcript. Yeakula Kanga Lawrence said, thank you, Mr. Chairman. Former Vice President Boakai said, thank you, Mr. Chairman. So they all acknowledge that. But it would be good to have them also testify. And hopefully they don't perjure themselves because the documents are there. The chat room, and that's also part of why it was extracted from the evidence, is because it shows them also acknowledging receipt of the messages about signing the final framework document and about the final framework document. So, but I agree with you. I think it will be good if they were to testify and have them testify for the court, but I doubt they would. It's really a thin line with perjury there, given the document, given if initially. So it's interesting because the Solicitor General was very sure that they were going to be his witnesses, they're going to come and testify. But that was before this evidence was, found to have been extracted. So now that evidence is now submitted in court and shows that they're acknowledging receipt of the document, we'll see if they will still come and testify that they did not receive the final copies.
They don't wish to come to court?
What he said was subpoena witnesses, so I believe that they're not voluntarily coming.
Oh, the defense can bring them. The defense can bring them.
Yeah, but that's what he said. They are subpoena witnesses. But listening to Councillor Jayweh and how our colleague wrap up the evidence with them saying thank you and all of that, acknowledging receipt of the document, it raised a question in my mind that sometimes people sign documents and are not fully aware or conscious of the contents of the document.
They don't read it.
Yes, they don't read it, take for granted that this is what we have done, so they sign it off. And when it comes to interpretation of intentions and what is in that people may have overlooked and all of that, the law has a rule that goes back to the author's rule. And so that's why when I'm doing agreement with my clients, I tell them that you have to sit with me so that at the end we can go through them one by one, atom by atom. Because if this document goes to court or there's a controversy over the lease agreement, I am drafting or the other party is drafting, anything that is ambiguous or questionable will first be held against the one who did the authorship. So if I'm doing this agreement for you, every responsibility is on me to make sure that it's clear. You cannot come back tomorrow and say you weren't aware, or you disagree, or you didn't understand, because I'm the lawyer and I'm the one who's drafting. So you have to come and sit with me. Let's go over every item one by one. And even when I do agreements, nowadays things are being done virtually. I tell them to find out, like I did an agreement for a company in Malaysia, for one of the parties here in the US. And I asked who drafted this agreement. They said it was the partner in the US. I said, okay, I'm in the US, I'm not his lawyer, but I'm your lawyer. So there are a lot of things that you have to understand. So let's go through it one by one. Find the time and let's do it. Because yes, your ignorance may not be, especially if I'm the one representing you. If you come back tomorrow and say you didn't understand anything, it will not hold because I'm in the US. I can contact those people and clarify anything on your behalf. So let's be certain that everything relating to this factory, is addressed. And I see some technical points there I want to clarify with you here.
And that's very important that you raised that, and that was done with the lawyers because the lawyers were the author of the final document. They amended the original Zoom document. So when the lawyers did the amendment, there was a meeting held at Liberty Party headquarters. In fact, the lawyers had what they call key issues arising out of the amendment, about 10 key issues that they have put in a separate document, and they had a meeting with all of the political leaders and the party chairmen and discussed those key issues with them. And there were no objections to any of the key issues. And so every time he laughing, he got me laughing. So because the lawyers were the author of the final copy that had been amended, they had a meeting, and that meeting was held. And even after that meeting, Mr. Cummings sent the document back to all of the political leaders and the party chairs, matter of fact. In fact, he sent the document to them when the lawyers submitted June 18. He sent it to them June. He sent it to them and told them we were having a meeting. They attended the meeting. Based on the confirmation from nobody objected to any of the key issues that was raised. And in fact, part of that key issues included the exit clause that is today say Mr. Cummings inserted. The clause that says to exhaust the dispute resolution mechanism within the CPP. And if
Right.
you cannot, you withdraw, but you can field a candidate. 8.5 of the document was inserted by the lawyers and was part of the key issues that the lawyers had in the document and that they discussed and it did not oppose to. So after that, Mr. Cummings again sent the document back to them for all of the parties to do the resolutions, approving the document, submitting the resolutions, and for them to sign the document. They had a meeting again early July. It was a Zoom meeting, I believe, and they all discussed how far the resolutions are gone. And because Mr. Cummings kept telling them we need to file this document because we need CPP to be recognized by next so we can field our candidates for the elections. So we're on a timeline that we're not meeting the timeline. So after that July, I think July 1 or July 2 meeting, and they all had, in fact, matter of fact, ALP even suggested that we remove the four because it said framework document of the four opposition political parties, four collaborating political parties. ALP suggested we remove the four because in the future you don't know if more parties will come on board. So there were small amendments made. He sent it back to them July 7th. So every time that document was discussed and son, he sent it back to them. And I think it's important you raise that point because you cannot now say you didn't see the document, you didn't know about the document. When after the lawyer's amendment, you have discussed the document, you have discussed the key issues arising out of the document, the key amendments the lawyers have made, including the exit clause. I think Dennis has a copy of that key issues document. The exit clause is in there. The exact provision is in there. Nothing changed from the provision. It's in there. He sent it to you early July. He sent it back again July 9th to you. The document was filed at next July 14th.
Thank you.
So I got a question.
Just for emphasis, please allow me to ask.
Hold on, Councilor, because this was just an icebreaker. We have not even gotten into it. And
but ice is not broken yet. I just want to ask Councilor Yeakula a simple, just for emphasis. So the lawyers, we'll go there. Then don't leave me in doubt before we go. Just for emphasis.
Okay.
So the lawyers' note included this controversial clause that everybody is arguing about that they were not aware of, did they approve?
Yes.
Oh, okay.
Yes.
I guess my question: why are the lawyers not in court? Why are they not witnesses?
The lawyers.
I know one of the lawyers, Councilor Benedict Sano. Why is he not in court? Why?
But the lawyers, when this issue started, the lawyers did a letter to the CPP. Letting them know that they were asked to make amendments to the framework document and they made amendments to the framework document. So the lawyer said that. And it's also a good question. I think the lawyers should. But the lawyers have stated that they made amendments to the framework document. The lawyers have submitted the copies of the amendment and the key issues again to the CPP. So, and the key issues include the exit clause that they said Cummings inserted.
So, I mean, that's a good question. The lawyers should be in court. I mean, I'm not a lawyer, but lawyers earlier said my hand inside, my foot inside doesn't make any sense.
I will subpoena them.
Yeah, but on top of this whole thing with the changes, here is another thing. The Ministry of Justice said they want to see Mr. Cummings his passport with the his Liberian passport with the American visa stamped inside. They want to see the flight number. I mean,
and that's a dead issue
and all that.
A mute issue.
So is it something because my question here is start with every time, because Mr. Cummings is a criminal defendant in this case, every time he's going out, he should ask for permission. Now they're saying when you even come from there, we want you to prove that you actually went. Is that something that is normally done?
And it's good that Councilor Verdier said isn't our moot issue, because that was an issue. And the lawyers responded, Mr. Cummings' lawyers responded. I don't know if you had a copy of that statement.
Yeah, they responded. They said,
but the issue was before Mr. Cummings requested, as per law, because the trial can continue in its absence temporarily. When he requested to go and see his mom, the magistrate granted the request.
Yeah.
And the Solicitor General took an appeal, went up for review to Criminal Court A. And he brought a stay order on the magistrate decision and said Mr. Cummings could not leave the country. When that conversation was being held, and Mr. Cummings' lawyers went back to the judge and said he has to go, that's when the Solicitor General requested Mr. Cummings' travel documents, which included his tickets to and fro the country. They submitted his tickets to Ghana, to the U.S., from the U.S. to Ghana, from Ghana back to Liberia, and the judge lifted the ban. At no time during that conversation did the Solicitor General request passport with visa in it. When the stay order was lifted, in fact, Attorney Horatio Good was on Spoon, and he was talking about the issue of the stay order, and Mr. Cummings, and then the Solicitor General came on and said, in fact, he was upset how Horatio Good is here on radio and he talking about how the stay order was not legal, but he other lawyer colleagues begging in the background, and he said all sort of things. In fact, I'm going to tell the judge to not let him go. In fact, when he coming back, I'm gonna bring his visa, I'm gonna see his visa and his passport, and he was on Spoon saying that. So apparently after that, he had sent a text or whatever, but the stay order had been lifted. The Mr. Cummings had been asked, like, given permission to leave, and he left. He saw his mom. I think he posted about it on his Facebook page. And then he returned to the country. When the complaint was filed on the judicial misconduct, prosecutorial misconduct, and the prosecutors from Ministry of Justice admitted that, yes, they excluded the evidence we just discussed, but it was inadvertent. There's a lot of public backlash against the Solicitor General. He decided that maybe to take himself off of this hot seat, he should come back with the issue of, now that Cummings is back, let him prove to us that he came back from America.
He actually won.
Then he gave us a visa. There is no law under our jurisdiction that says a defendant in the case who's returned, having been given the permission to leave, should come back and show visa or show travel documents. He showed his tickets when he was leaving, and this is just to distract us from the issue of prosecutorial misconduct, and this is just against CFA's usual shenanigans and public display that I think at the end of the day I wouldn't give any air to. But as the counselor rightly said, that's a moot matter. Mr. Cummings has been granted approval. He's left. He showed his tickets before he left. He's returned, and we move on.
Right. So my question here is: this going to be the way it will be anytime Mr. Cummings is traveling? If he's because if he's going to Sino, or if he's going to Ghana, he's going to Nigeria, is he going to be required to present these things every time? Is that the way the law works? Councillor Jayweh, you can take that.
Let me. In a criminal proceeding, when you post a bond, you commit yourself to the court that you'll be present at all times unless excused by the court. And so if you're even traveling from Monrovia to one county, you will need to inform the court, you will need to get permission because the trial could be going on and the court would want you to be there. So yes, if you, as a defendant in a criminal matter, you will have to make yourself available to the court or ask for an excuse, and that excuse has to be granted by the court in order to travel, whether it's in Sano, Grand Jita, Maryland, anywhere else in Liberia or outside Liberia.
And you need evidence to show that you are traveling to these places.
Yeah, when you submit, you will submit a request to say you're traveling. Let's say you're traveling to Lofa,
right?
And there is a clinic there that Mr. Cummings had donated 5 generators, and they want to go ahead and officially install the generator. And he thinks it's important. You have to inform the court that I'm driving to Lofa County. Here's the reason, and so forth. That's in Liberia. Also, Liberia, you have to show. And what is interesting to me, and I heard Attorney Gould did jump around, did not answer the question. Was that no one travels on ticket. when you wish to travel, when I'm traveling from the United States to Liberia, I will buy my ticket in order to be able to get on a plane as a person who can travel by maybe Delta Airlines or any other airlines. But it is required that you have a passport to travel. What I don't understand is that at what point did the Solicitor General request that Mr. Cummings should submit his travel documents, excluding the passport? I don't understand that. And I know that currently I understand that a bill of information has been filed by the Solicitor General at Code A, specifically requesting that Mr. Cummings produce his passport, his Liberian passport, with a U.S. visa in it.
Right.
If that was not part of the conference that caused Mr. Cummings to leave Liberia, then the bill of information would make no sense. Because it was not an issue before. Why is it an issue now? But if, according to his bill of information, that his ticket, the state he was visiting, his passport, everything else was requested, and the understanding was that when he returned, according to the bill of information, when he returned, then he will produce his passport. Now, what is the essence of the passport at this stage? If the essence is to establish that Mr. Cummings is not a Liberian, there are many other ways that it can be done. I would not, as a trial lawyer, waste my time in court to begin to act for it at this point.
But when you come back, Councillor,
I will subpoena Mr. Cummings. I mean, I will cause the court to subpoena Mr. Cummings to bring the document. I will not be doing bill of information. It's like a waste of time to me.
But wait, if Mr. Cummings comes back, does he have to show that he does he have to report himself? Say, okay, I'm here now. Even though I asked, if he came from Lofa, does he have to show that his car is all dusted up to prove that you're from Lofa?
Let's say if the court gave him 2 weeks to travel out of the country, unless he stay outside of the 2 weeks. Right. Let's say he spent more than 2 weeks in the United States, then there are issues there. There could be contempt, there could be investigation to find out. I think, and what I've all heard is that the state is interested in whether Mr. Cummings is a U.S. citizen or a Liberian citizen.
Why is that important?
What does that have to do with the current case that CFS is prosecuting?
Well, the thing is, that's why I said I would, if I'm interested in doing that as a prosecutor, I would not bring it in this matter. I would subpoena, I will cause, the Minister of Justice is responsible to determine who is a citizen, who is not citizen. I will subpoena the immigration to bring travel documents on Mr. Cummings.
So you can Councillor, help me understand. I mean, the Ministry of Justice can just randomly wake up and say, Commissioner General of Immigration, bring us document on Moriah's citizenship or travel document on Moriah's passport.
So because if the state raises let's say the state is not, let's be direct, if the state is not sure whether Mr. Cummings is a Liberian or not, and the state has interest, and I am the prosecutor, I will not raise that issue in this trial because it will not make sense. I will not do that.
It doesn't make sense.
Yeah, that's what I say. It doesn't make sense to raise in this trial. What I would do, if my interest is to ensure that Mr. Cummings is not a Liberian citizen, I will raise it in a different proceeding. That is, I will commence an investigation as to whether or not, as a non-Liberian, you can run to be president of Liberia.
Why is that issue coming?
But is that an issue today in this case?
Yeah, it doesn't even count. It just shows the bias.
I'm showing to you that
of
what is
the Solicitor General.
So we have a Solicitor General who's prosecuting a misdemeanor forgery case and now wants to raise an issue about citizenship of the criminal defendant?
I don't think it belongs in this case. That's what I said. It doesn't belong in this case.
So, and that's but the bill of information was filed in connection to this case.
Oh yeah,
Like he asked for leave. And just to answer your question, Councillor Jayweh, the travel documents were submitted before Mr. Cummings left. So if the issue of passport or the issue of visa and passport were raised before then, that would have been addressed before he left. So he submits his travel documents before he left. He comes back, then he says, but submit a passport, let's see a U.S. visa in it. He can go to the U.S. embassy and ask them for visa.
Thank you. Let me bring in two questions here from people.
Before you bring in those questions, Mr. Host, I think you are not breaking the ice, you are crushing the ice now. But before you shift, I would just like to say that in the practice of law, some things are expedient, but they are not legal. And other things are legal, but not expedient. The Solicitor General approached this matter with a bias, and he doesn't know the difference between what is expedient and legal. And so he has just created a whole lot of hullabaloo and all of that kind of thing. The man has filed a bond. Like I said, it's a moot question that we shouldn't even be bothering with. He filed a bond. It is the right of the defendant to be in court. It's not a right of the prosecutor to insist that the defendant should be in court. And he files a bond, as Councillor Jayweh has just said, to secure his presence. That's the reason why he filed a bond. Okay, so his movement has nothing to do with the case, except where he is compelled to attend at a particular time. But if court is not in session and he wants a leave to go, what does the prosecution has to do with it? It's between him and the judge, especially at that stage of the case.
Councillor Verdier, what you are saying is Mr. Cummings is not required. He can leave the country anytime he wants, as long as he has secured a bond. Is that what I'm hearing? He
has his freedom to move around. If he is a flight risk, the judge, before approving the bond, would have put restrictions. Now, that's why I'm not familiar with the case and all the details. The judge would have placed restrictions on the qualification of the bond. I'm sure there was a bond hearing to test the bond to see whether it was good enough, and the judge came up with a ruling. If the judge had ruled that you would not leave this jurisdiction of Liberia without the approval of the court, that is the rule. But if the judge didn't stay so and he filed his bond, and he's not a flight risk, he's free to move in and out, just to make sure that he's in court all the time when the case is called for hearing. It's his right to be present in court.
And how would the court ensure that he's in court all the time?
It is his right to be in court. Okay. It is not the right of the prosecution to demand that he be in court. Whenever the prosecution wants him to take the stand, he should be available. Whenever the judge needs him, he should be available. But whether he stays out or not, that's the right of the defendant to be in court at all times. That's his right.
Thank you, Councillor Jayweh. You said the opposite. You said
so. There's a real difference between a criminal trial and a civil trial. When a civil trial is proceeding, you can leave, you can go. If you're not testifying or it's not even your turn, you can leave the country if you want to. Look like you can go to San, or you can go anywhere else you wish to go. If it is a criminal trial, the purpose of the bond is to ensure that the defendant is present in court on a day-to-day basis, unless excused by the court, because you have committed yourself to the bond. And if you are not present, you don't have an excuse. The sureties, people who sign and say we will be bondsmen for you, can be summoned by the court and requested to know where is the defendant. So you don't just run around. You can't just leave the country and you think you can go. No, you must file. That's why when you get ready to leave, because of the criminal nature of the case, some of your liberty will be restrained, including your right to just leave if you wanted to leave. You have to file a request to the court indicating that you wish to travel to London to see your 70-year-old dad who is about to die. And the court would reason out and grant you. Other than that, you don't need to go to court and tell the court, I'm going to London or I'm going to the United States. You must request. You got to request because you are a property partially of the court in a criminal trial.
Councillor Jayweh, I mean, also the very civil procedure law provides for voluntary absence of the defendant with no condition attached. That
Oh,
does not stop the trial from continuing.
it doesn't work automatically.
No,
A
I'm not saying
voluntary,
it works automatically. I'm saying it provides for defendant to have voluntary absence from trial while the trial continues with no condition. The
correct.
law does not, yeah, correct. So the law
The
does not provide for conditional voluntary absence that the defendant has to do A, B, C, and D before they can leave voluntarily during the trial.
so
So
you
a
can,
defendant, like he said, is the defendant's right to be present at the trial, and yes, a bond is filed for the defendant's presence. But even in a criminal trial, a defendant can be voluntarily temporarily absent while the trial continues, and the court will grant the defendant that temporary absence without any condition.
no,
So in essence,
the condition doesn't
hold on,
matter to me.
Councillor Joy, Councillor Anthony Yeakula. So in essence, you are saying Mr. Cummings is not required to ask the court for anything. He can leave the country or the capital city anytime he wants.
No, he can inform the
That's
court
it.
that he has
Okay.
to leave, but
Okay.
there's no condition on his leaving to say you got to bring this, and this. Usually,
Precisely.
because of the how do you call it? I won't say camaraderie, but because of how the system works, it's only reasonable that if I say I want to go see my mom in the US, I will show you that I'm going to travel to the US, that I have my tickets and stuff, and say I'm going to travel to the US and I'll be back in so and so date, and informing the court. And that's me requesting my voluntary absence while the trial continues. Because even when Mr. Cummings was in the US, the trial continued, except that on the day that they called the case, the prosecutor said they were going to the Supreme Court, so they didn't have trial that day. But the trial continues in its absence, right? So you exercising your right to voluntary absence is to inform the court and say, I'm going to go to Maryland County for this program, like Councillor Jai said, or whatever. And you can show that, yeah, you're going for the program, but it's not a condition. The court cannot put conditions on your voluntary absence from the trial temporarily and say, before you go. So when those things happen, it's really to ensure that, okay, yeah, you're saying what you're going to do, or you're saying what you mean, but the criminal procedure law does not put conditions on defendants who are requesting voluntary absence. So for example, and I should say this, what if a defendant has a terminal illness? What if a defendant has some personal confidential issues that they need to address, right? And you say you must do this, and this. So the in the particular section of the law is section 2.42, which has no effect on the continuance of the trial when a defendant requests temporary, that's what the law says, temporary voluntary absence from the trial. So in
And
this
the
case,
court cannot deny that too.
the court should not deny that, because it's the defendant's right to be in court, and it's the defendant's right to request a temporary voluntary absence. It's not to say I'm going to leave the trial, I won't be back, or I'm not coming to trial anymore. It's saying for a week or two, temporarily, I would like to a voluntary absence, and the court can grant that, which is why the magistrate, remember, the magistrate granted the request when the defense lawyers made the request for Mr. Cummings to travel to see his mom. The magistrate granted the request. The magistrate did not ask for X, Y, Z, and D. He granted that as per the law and the defense right to a temporary voluntary absence. But when the prosecution challenged that and went up to criminal court A, that's when the judge asked, for those travel documents, the tickets and stuff, and it was submitted to show, yes, I've already booked my tickets. I'm traveling to go and see my mom, and it just, okay, lift the stay order and go. So all of this issue around bring your passport and your visa, let me sure you went to America, bring this one. I think, as Councillor Verdier says, it's moot, and we shouldn't give it air or waste our time discussing it, because it's just part of the SG's shenanigans. At the end of the day, in any serious country, where the rule of law is respected, this will not be happening. And Councillor Jaya was right. A bill of information at this point, it doesn't make sense, because You found a bit of information on a travel that has already happened. The person already traveled and came back. And then you send a bit of information and say, bring a passport or visa. If you want to go into the issue of citizenship, go into the issue of citizenship. That is separate from this trial,
Correct.
this misdemeanor trial. But trying to tie the two together is how does it affect the other? And at the end of the day, one of the things that the Liberian people need to realize and understand is today is Mr. Cummings, but under the law is something called precedence. And once that precedent is set, it's for everybody else. It's for everybody else. When we continue to sit and allow the Solicitor General, the prosecutors to, flagrantly violate our laws and set new precedents, because the way the law is set up is there's not one law for me and another for you. There's not one law for Cllr Verdier and another for, Cllr Jayweh. The laws should be blind. The administration of justice should be blind to everybody, and everybody should be treated equally under the law. And this is not what we're saying. There are different, things coming up when it comes to the issue of Mr. Cummings, and just changing the goalpost here and there and going after him for things that makes absolutely no sense.
Thank you. So to clarify, this is a misdemeanor for Mr. Cummings, but it's okay. Councilor Joy wanted to say something because I don't think Councilor Verdier want for us to finish with this ice today.
No, I will help you crush the ice, no problem. What I wanted to say when we speak of judicial reforms, the way our laws have been practiced and interpreted historically, culturally, and contextually is to suppress the rights of the people of Liberia. And those are the things we speak against when we see there's a need for judicial reform. There's a need to review the practices of the court. Some things are very, very basic, but because the prosecution wants to delay or wants to suffer or wants to punish a defendant even before the end of his trial, they come in with a whole lot of shenanigans and things just to frustrate you, to deny you rights, to impede your progress,
right.
For you to see or feel their power.
Right. But that's
what it's about.
Is that illegal, or they are taking advantage of the law?
They're taking advantage of the loopholes in the law, and they're taking advantage of the fact that people don't normally question. Some of them are illegal, but people don't bother with them. So because they are in position and they are oppressive and suppressive, they take advantage of people who don't notice. But just as we said, it was just waste of time most of the instances.
Yeah, I don't think Councilor Jayweh agreed with you. And Councilor Verdier, when you were starting, you said the laws in Liberia are meant to suppress. I didn't get that part clearly.
It's being interpreted and enforced in a way to suppress ordinary Liberian citizens. Look, when a policeman goes to make an arrest, how he does it. He shows no respect for the person he's going to arrest. He wants to show that he's in power. He wants to show that he is the authority. And it cuts across the wider spectrum of government actions, government enforcement, government rules, government regulations. That's how it's interpreted and that's how it's enforced. And the councillors spoke of precedent. If you do it today and nothing happens, you do it tomorrow, then that's the way it is. And our laws, nobody can deny or challenge that, have been oppressive and very suppressive of the rights of Liberian people. And most of what is happening now in the courts and in the processes that will happen in this Cummings case is not expedient, and it doesn't find solid grounds in the law. But it happened before. People are not challenged, and people feel they can get away with it, and they do it. So it's Cummings, an honorable man, a prominent citizen. Imagine what he went through. Then think about a person who cannot even afford to file a bond. Many of them are lingering in prison without trial for more than 100 days, for more than 3 months, more than 4 months, more than 5 months.
More than 4 or 5 years.
Yes, for years. That's how suppressive the law is. And those are the kind of things we have to change.
The enforcement of the law, but you are saying both the enforcement and the interpretation are also.
The interpretation is the courts that interpret, is the prosecutors and the lawyers that help to interpret the law. And most of the time we go to court, we want our way to be done. And so it leads to negative and oppressive and suppressive interpretations. And it puts pressure on the judge most of the time to accept it. That makes our laws bad.
Councillor Jayweh, you wanted to come in.
So in order to challenge a bill, a bond, in fact, when a defendant is arrested and he or she is brought to court and he submits a bond, the state has, the statute provides for 3 days for what is referred to as justification of the sufficiency of the bond. In this case, in the Cummings case, there was no justification of the sufficiency of the bond. The prosecution came to court and said, I think I heard the Solicitor General saying that Mr. Cummings is an honorable man, and so we have the bond to stand. Now, what my problem is that lawyers are hired to defend the client. So what the lawyer do is that the way you defend your client has an impact on your client. If the conditions for bringing passport, for bringing tickets, for bringing the state you visited were not issued because the defendant was considered an honorable man at the time the bond was filed, it cannot become an issue when he wishes to travel.
Of course.
But if you, the court will not do for party litigant what party litigant is supposed to do for himself. If the state raise an issue like that, which have been raised during the bonds process, and it is now coming up in the middle of the trial for Mr. Cummings to travel, what was wrong with the defense counsel? Where were they? To say, Your Honor, this is a moot issue. Such an issue should have been raised for during the justification of the bond. The bond was not justified because the state considered Mr. Cummings as an honorable man. If you sit there, you don't do it. You don't do anything about it. And you present document. You're actually supporting the prosecution to continue with what it is doing. But rightly, you must object and say, this is not where it belongs. And it must have been done at the time the bond was before the magistrate court. So I'm not saying a condition should be attached because I don't think it makes sense. But at the end of the day, what happened to the Council of Verdier chair?
I think he had that issue.
Yeah. So if the responsibility of the defense to defend Mr. Cummings and to make sure that issues are not raised belatedly. Those issues are raised on time. As a trial lawyer, you must ensure that those issues are not raised belatedly, and they are not allowed to creep into the trial when they have no business doing it. Why were we asking for passport now on the bill of information? Why are we asking for a ticket? When the bond should have been justified and at least the issue of whether Mr. Cummings is a flight race should have been raised during the bond period.
But I think Councillor Jai, in defense of his lawyers, they did object to this issue and said it was moot and that they were not going to entertain it. What we're speaking to is the statement they put out for the public. But I think as to the bill of information, they've been clear that they're not going to entertain that issue is moot. And when the prosecutor or the opposing party decides not to challenge a bond, like you rightly said, you cannot come back now and say, you have to present X, Y, and Z when that stuff should have been done. But I think Mr. Cummings' defense lawyers has been on top of their case, and this is why they're able to identify all of these things and try to nip them. Even the issue of the extraction of the evidence. That stuff, yes, it was over 100 pages, but if they had not read line by line, they would not have got the extraction, because that stuff jumped from July 2nd, the transcript, because if you look at the transcript, it gives you the date and the sentence. It jumped from July 2nd straight to July 19th. So if you're not careful and you're reading the transcript, you could have missed it, that a whole conversation from July 2nd to July 19th was extracted. So, but it's because of how detailed they are. It's because of the time and the interest they put into this case is why they were able to even catch the fact that there was an extraction of the evidence. And it's because of how, like, they've been on CFA's back, on the Solicitor General's back, is why these things are happening. Because even when he runs up to the criminal court A, they go there and they challenge it. When he comes back with his issue of the passport, they make it clear we're not going to waste our time on this stuff. It's moot. And stuff. So they've been on it. And when CFA said in open court that Mr. Cummings is an honorable man and he wasn't challenging the bond became valid. So you cannot come back now and say do this, that, and the other, because again, like the defense said, they're not going to waste their time on a useless bill of information when this was not an issue raised before he traveled.
Thank you. At this time, we're going to take a short break. When we come back, we're going to read comments and take calls. Again, the number to call to join the conversation is 605-313-6004. The code is 791403. We're going to take a short break and then we read our comments.
Focus on Liberia. We discuss everything Liberia, from education to politics, arts and culture, entertainment, agriculture, history, religion, family, and technology. Focus on Liberia uncovers and showcases the best of Liberia and shows the world the truth about Liberia. We educate, elevate, and promote all things Liberia. We conduct interviews, panel discussions, debates, and more. Tune in to Focus on Liberia on Facebook and YouTube and be a part of the stories that make up the news.
This is Focus on Liberia, and I am Dennis Jah.
Welcome back to Focus on Liberia. This is the FOL Justice Forum, and we are broadcasting from Atlanta, Georgia. In tonight's edition, we should be talking about the Supreme Court, but we are still on our icebreaker, which is perfectly fine. We can do that all day, and we're going to have you back next week. So at this time, we're going to go through our comments. Our friends are commenting, and we want to bring them in the fold. This one comes from Zeus Carter. It says, from my layman knowledge, the entire case stemmed from what is called in the legal field the unclean hands doctrine. That's why I see no merits in this case. Councillor Verdier, do you agree? I don't know what unclean hands doctrine is.
I don't know myself.
Does anybody know? Or this guy is trying to...
Well, I know there's a legal maxim that says if you want equity, your hands should be clean. Meaning that if you want justice or if you're accusing somebody, you yourself should stand in position of equity and truth to be able to do that. So, but I don't know what he calls clean hand doctrine. Maybe everybody should have their hands clean when they come before the court.
I think he's referring to what you just said.
Okay.
He might be referring to, ensuring that justice is done and apply the law in an equitable manner.
Yeah.
And Councillor Yeakula, it's okay to get a hug, okay?
To get what?
So it's okay to get a hug. I saw someone giving you a hug. That's perfectly fine.
Oh, okay. I thought you said.
Attorney Merrill Theo Barrio said, Councillor Jayweh, once the case is dismissed in that fashion, based on a question of the law, double jeopardy attaches. Therefore, the state cannot appeal, as it will be tantamount to try the defendant twice for the same crime.
This is a lawyer?
Yeah, he's a lawyer. I know him.
Okay, so I don't know what. You want me to address that?
Yes, please.
I don't know what he means. This is not the.
Yeah, he said it at some time. Oh,
if the state should lose the case before the magistrate, and Mr. Cummings should be acquitted. If the state decides to appeal, it's not double jeopardy. It's just a legal process that the state is trying to exhaust. Double jeopardy is trying somebody 2 times on the same offense. So the matter traveling from in fact, the process for the magistrate court is that the records are, made, photocopy and sent to the clerk will send it to the clerk of court in court A. And because the magistrate court is a court of non-record, the case will be heard de novo. It will be heard as if it was just starting there. So there's nothing with double jeopardy. There's the lawyer we're asking for, but that's not what double jeopardy is.
Thank you. There has been a lot of questions on the Solicitor General. So let me put a few on the board so that we can all look at. They'll say, furthermore, the job description of the SG is modeled after the U.S. judicial system is to try cases or represent the government before the appeals and Supreme Court, not the lower court. But in Liberia, everything is done upside down. Serena Cephas has an axe to grind against Mr. Cummings. People have said a lot of things, about. So I want to read a few of them, and then I can let you respond. Zeus continuing. Serena Silva wants to trap Mr. Cummings that he's a U.S. citizen and therefore cannot contest in the election. That's why they are playing this deceptive game. At no time was Mr. Cummings at flight risk, so everything else is irrelevant. My question is, what is this Solicitor General doing wrong? Because in the first place, when this case came up, we were told, oh, why is the government taking over the case, and why is the Solicitor General doing X, Y, Z? He is not ALP, or he is not Mr. Benino Ure. But we were told on this case, on this show, that because it's a criminal trial, the Solicitor General should be doing this. But what is he doing wrong in this case? That people are talking about him, his name spoiled in the community. Moriah, let me start with you.
I think first things first, for those who've been following the case can clearly see what he's doing wrong. Yes, the government prosecutes criminal matters. But as we mentioned earlier, it's surprising. If not, I'm not sure if Councillor Jayweh, you've been in the legal field long. If you remember a case of such, please let us know, where the Solicitor General himself has prosecuted a misdemeanor case at the magisterial level. It's almost like having Cephas going to West Point Magisterial Court.
Oh, be careful how you bring out West Point.
Well, I mean, it's a magisterial court, or Gardnersville Magisterial Court. I'm citing other magisterial courts because the Monrovia City Court is a magisterial court, like other magisterial courts around the country, or Gardnersville Magisterial Court, right? So having the Solicitor General of the Republic of Liberia prosecuting a misdemeanor at the magisterial level says a lot to a lot of people in the legal field, because you have cases of armed robbery, rape, murder, trafficking, money laundering, and you name, like, felonies that he's taking time away from to focus on a misdemeanor. And the Solicitor General is not the only prosecutor at the Ministry of Justice. They have an entire prosecution unit. So why is the Solicitor General prosecuting a misdemeanor at a magisterial level? That's the first thing. Secondly, when you take a complaint to the government and say this person did X, Y, and Z and it's a crime, or they committed a crime or perjury, the government, the prosecution, has the responsibility to investigate, to find probable cause before a writ is even issued, a writ of arrest. And the Solicitor General issued a writ of arrest without even investigating this case, because had he investigated, in fact, let me backtrack. He did. He investigated and he saw that there was no merit to this case. He saw that the allegations against Cummings were bogus, and that the evidence showed that they all were aware of the final framework document. Yet he extracted that portion of the evidence to be able to bring these bogus charges of forgery. That's the first thing. Because now we've realized that, and they've admitted that the extracted evidence that actually shows that Mr. Cummings submitted this framework document to all of the parties of the CPP, and they were aware of this final framework document. So if there was any changes made to it, they could have seen those changes before it was filed at the NEC. But he extracted that. So it clearly shows that the Solicitor General purposely went through what was submitted to him, extracted the evidence that was against his case, just so he could bring a bogus case against Mr. Cummings. And that's why he's the one prosecuting this case at the magisterial level. Let's talk about the case starting. You submitted the discovery. In your discovery, you submitted the soft copy of the original framework document, which everybody knows was signed on Zoom, and there was no official hard signing of the document because then it went directly to the lawyers to be amended after the public backlash on the clause with the job issue. You come back and say, yeah, the document was signed on Zoom, but there was hard signature, bring the signed copy. You promised to bring the evidence against yourself. People raised eyebrows. Like, how can you be prosecuting someone and ask them to bring evidence against themselves or bring something that you claim they forged and they have copies? And he says this document doesn't exist. We signed it on Zoom. We're on a Zoom call right now. I'm sorry, on a online show, right?
Same thing.
If we sign in a document and I have my copy here and I sign it, have you signed this document, Dennis?
No, I wouldn't have done it like that. I would have put it on the screen for us to sign using the whiteboard.
Right. But if you have a copy, I have my copy, everybody has the copy, we're on the Zoom call, and we sign for the public who's watching. Right. I only have this copy. You only have what you have. Everybody have that. We never sat down in the same room to sign one copy. So how can you come back and say, bring the signed copy of that document on Zoom? And immediately after the Zoom ceremony, we're sending this document to the lawyers for amendment. So the Solicitor General comes back and said, Cummings has the signed copy from the Zoom ceremony, bring it. He says it doesn't exist. There was no signed copy of all of the signatures. It doesn't. What exists is the soft copy that we all have copies of that we individually signed. So I can give you the copy that I signed, but other signatures are not on it. So people have seen how he's proceeding. Now, through the case, Mr. Cummings comes and says, Mr. Cummings has attended every single case that was called. Every single case, he's been present. And he says, okay, I need to go and see my sick mother. And the judge said, okay, fine, go see your sick mother. Solicitor General runs up to Criminal Court A and said, no, put a stay order on his travel. So people are saying that this is not even about the case, it's more of a personal vendetta. That the powers that be and the government is using the Solicitor General to then go into issues that they think they have with Mr. Cummings. We've heard several theories. Oh, they're blaming Mr. Cummings for sanctions that are coming on them. They're blaming Mr. Cummings for lobbying in Washington against the government, because when they come to Washington, not only Mr. Cummings' name they can hear. They're blaming Mr. So they want to get back at him. They're trying to get Mr. So at the end of the day, if you say, what is the Solicitor General doing wrong? I think the public has seen that this is a personal vendetta, that this it's not about the law. This issue is not about a case, because the case is clearly bogus. This is about getting back at Mr. Cummings because his bosses, so this Serena Sifa's bosses, believe they have personal issues against Cummings for what they think he's doing.
Thank you. Councillor Verdier, same question. Let's look at Solicitor General.
Well, there's a political dimension I wouldn't want to address.
Right.
And I think Councillor Yeakula has spoken well to it. I spoke of the suppressive nature of the law, how people use the law to suppress other people. Yeah, right. The Solicitor General, I don't know if you guys know, he was a rebel before. He operated in Maryland County. Yes, he was a G2 commander. And he, from what we gather, he married somebody there, and it was because of his position. And he has not been demobilized. And so the suppressive nature is within the Solicitor General.
Is that from the TRC hearing?
I don't know what you mean by that.
I mean, what you are saying now about him, is it as per the TRC?
As per investigation before and after the TRC. You know, the TRC didn't complete all of this work. Right. And there were requirements for continuing investigation even after the TRC.
Okay, I just want to make sure that his name is in the TRC report or not.
Well, I don't think His name is there. I will not remember. It's been a long time, but not all perpetrators' name are named in the TRC report.
Just for
Yeah.
clarity. Go ahead. Sir.
Okay. Yeah, so that's why the Solicitor General, I shouldn't be very negative against a colleague, but it's unfortunate. And like I said, because Yeakula has spoken today, there's nothing more I should say. But on the political side, you can see that the government has some interest. And where does it come from? It goes back to President Salif and her interest in the political dispensation of Liberia. And Mr. Weah thinks that Cummings is being given a lot of preference and Cummings should be suppressed. So the perceived innocent case of Mr. Bernard Yeakula is being politicized because high-ups have interest in not prosecuting, but prosecuting Mr. Cummings for political reasons. And that's how this case has taken. And that's why you see the Solicitor General has been anointed to take over this case himself.
I like that.
Councillors, yes. Councillor said that there are several prosecuting attorneys associated with the Ministry of Justice, but with the personal interest of the Solicitor General is questionable. He's doing his work, but like we said, not everything is legal, and not everything that is expedient is legal, and not everything that is legal is expedient. You can't stop him from doing his work, but there are other cases. There are a lot of rape cases that are not being solved. Right. There are a lot of prosecutorial questions that are bound without redress. So he's doing his thing, and unfortunately, the God we serve doesn't like, okay, your hands will show. If you are not correct, yeah.
You mentioned something. You said the perceived innocent case of Bernard Yeakula. What does that mean?
Meaning that Bernard Yeakula, all he knew, he was complaining Honorable Cummings because of what he think went wrong within their organization. Another platform I was on, maybe it was this show also, I said if I was the judge, I wouldn't have been so hasty in issuing a writ of arrest against Honorable Cummings, because that's an organizational matter. Things came up based upon what they were doing internally. There are different approaches that you could have, but maybe he saw that a serious crime was committed, and that's why he hastily, or I agree with them when they issued. And you heard what Councillor Yeakula said? CFOS had enough time to investigate and peruse documents and all of that. At first, she wanted to say he didn't investigate well, but now that was giving him the credit to say he didn't investigate well to know what was obtaining. But on second thought, if he can extract evidence, it means that he investigated well and he saw reasons and the means by which he could come in to perpetrate a persecution based upon political motives outside of the law or the case that was filed against Honorable Cummings.
Thank you. Councillor Jayweh, same question about your colleague, Saruna Sifas, the SD.
I like to stay within the framework of the law. There is no provision in the criminal procedure law or in the penal code that bars a prosecutor from prosecuting cases at the magistrate court. I will prosecute case in the magistrate court if I Solicitor General. I will prosecute in Yeakula magisterial court if I Solicitor General. In other words, there is no legal bar to where you prosecute the public or like you prosecute cases. So we should not give the impression that because the Solicitor General is at the Moriah City Court, other cases are left undone. It is trying to interfere into what the Ministry of Justice should be doing. And so, in that he is, I have said that Solicitor General C4 is a dramatist. I said that because, number one, I've seen him on many shows, and I have said that the courts in Liberia need to take judicial notice that people don't argue matters in the press instead of in the courtroom. I've heard things like, the case should finish, Mr. Cummings will go teach at whatever other school, GW case.
Yeah, he said that.
I've heard him saying that, I'm going to talk about fairness and equity in the society. All of these things are happening because apparently the courts are not taking real notice and disciplining the lawyers. But equally so, I've seen the Minister of Justice, former Associate Justice Banks, and now a magistrate, he appeared before me several times. So it depends upon what the government has interest. Now, in all criminal cases, the government of Liberia is supposed to serve as the chief the prosecutor, in fact, not even chief, the prosecutor. So whether it's in Yeakula, whether it's in Soniwe, whether it's in what the other place, Boniwe, or Spanish, you can appear there. In fact, it's important because if you appear there, you are supposed to be able to be doing your duty. I just don't believe that all of the discussions of what will happen if the court should convict Mr. Cummings, you go this place, go that place. I don't think it makes sense, and I think it's tampering with attempting to influence the trial as the case would be. But he can appear in any court. He can defend people anywhere. He can choose to issue, having read the facts. If his legal mind tells him that there is a probability of cause here, he can ask the magistrate to issue a writ of arrest. It is a duty to prosecute that writ of arrest to ensure that he wins. If he can't prosecute it, the court will dismiss it. So there's no code that is limit for the prosecutor to appear.
Thank you.
Dennis, can I comment? I think Councillor Jayweh raised a very important point, and we did acknowledge that is the right of the prosecution to prosecute crimes, any case that falls under the definition of crime as per our penal code. The prosecution under the Ministry of Justice is responsible to prosecute that. And it's also important that he mentioned if the government has an interest in the case, which clearly seems to be the case with Mr. Cummings. Because yes, the Solicitor General can go to Yeakula Magisterial Court, West Point Magisterial Court, other magisterial courts, but it will be interesting to hear or to note what other misdemeanors at these magisterial courts the Solicitor General has prosecuted since he became Solicitor General.
But Anthony, Mr. Cummings is a high-profile person, so
of course.
So why would the Solicitor General want to have his finger?
That's the elephant in the room,
right?
Because all of these magisterial courts have solicitors assigned to this magisterial court. At the city court, you have city solicitors there assigned to work along with the private prosecutors to prosecute these matters that comes before the magistrate. I know that for sure because in my practice we work with David Wilson, Attorney David Wilson, Councillor David Wilson now from the Moriah City Court, who's a city solicitor. So you have these people who are there to do these things, but the Solicitor General comes in, and yes, it's his right to decide. But I'm glad that you said because Mr. Cummings is a high profile, so the Solicitor General decided to take the case, and that just speaks to what the government interest is in. The fact that, as Councillor Jayweh said, CFAS is a dramatist, which again goes to why he even asked the court to go against its own rules of bringing cameras into the courthouse to televise the trial. You remember that? He wanted the trial televised so he can perform.
Talking about dramatists, I have my favorite lawyer, right? I have my favorite lawyer, and it is not related to what we're saying, but I just want to play it so that you have an idea. Take a listen.
But this is the catch here. Dr. Belete is suing Senator Darius Dillon not because he won the $1 million. In fact, he told me, I said, no. I thought when that damages have been paid, I don't want it. I said, give it to me. I want it. Okay? But it is to teach Senator Dillon a lesson so that others must know, because this is a man who is the senator of Monserrado County. People follow these people.
I like him.
He's my former student. I taught him at Zion Community College.
We want to bring on our caller, but before that, two comments here. One from Abraham. He said Mr. Cummings is being prosecuted because it's alleged that he paid lobbyists to lobby Congress to impose targeted sanctions on corrupt government officials. I mean, I get all this part, but let's talk law here today.
That's not law.
Right, that's the politics.
Councillor Lafayette Good, he said, Councillor Jayweh, we objected and we have no time for an issue that is mute. That's pure nonsense. And full disclosure, Councillor Good,
Attorney Good can say that though.
Yeah, I think he was talking about the Bill of Information.
Oh,
yeah.
okay.
So let me bring him. Our only caller on the line here is Evans Morris. Evans, you are live. Thank you for joining.
Thank you so much, Mr. Jai. Thank you to your panelists. Thank you for sharing your time with us. I have two quick questions. My first question is for Attorney Yeakula. Quickly, I want to ask her if she's a member of the Liberian Bar Association and if she can practice law in Liberia. And a second part to that question for her is, what motion will she have raised concerning the temporary evidence in terms of withholding those information from the text messages? What step would she have taken? Yeah. And then quickly to Councillor
Jayweh? Verdier, okay.
No, Councillor Verdier, yeah. In regards to the TRC, quickly, I know it's a bit off topic, but it's also a legal issue. What legal remedy do we, as the people of Liberia, has to take against the government, even though the government is supposed to represent the people, but in this case, they seem to be going against the people as well. So what legal remedy can we take to, I guess, force the government hand to implement the TRC? Because I haven't seen any lawsuits or any of our great lawyers fighting on behalf of the people to try to force the government to implement the TRC. Those are my two questions. Thank you very much.
Thank you. And join us on Wednesday night. We're going to be talking about memorialization and the historical, of the Civil War. And we have a transitional justice expert who's going to be our guest. So also join us, just in case you don't have your answer today.
All right. Thank you.
Thank you. So, Attorney Moriah, you have the first question.
Yes, I am a member of the Liberian Bar Association, admitted in 2017. So it's been 5 years. 2022 makes that 5 years. And I'm also a member of the Nima Bar Association, being from Nima County, and a member of the Association of Female Lawyers of Liberia, AFL. So yes, I'm licensed to practice in Liberia and members of these bars associations. Hopefully next year I'll be sitting for the Councillor Bar. Thank you. So to that question, on the issue of what motion, I think the lawyers representing Mr. Cummings are doing an extremely good job, and they've done exactly what I would have done. They have raised a complaint against the Solicitor General for prosecutorial misconduct. It is being investigated. It is good that last week the prosecution admitted to extracting the evidence and said it was by mistake. It is now left with the judge to finalize his ruling on the investigation that he had launched based on the complaint. Based on the ruling of the judge, I believe the defense will determine the next appropriate actions, which I will fully support. And I'm also in touch with the defense as well. So not giving any legal strategy out there. I just want you to know that they're doing exactly what I would have done, and they're doing a really good job.
And Councillor Gu is here, who is part of that team. He says, no, Councillor Jayweh, you are wrong. This case is cognizable before the magistrate. Therefore, if Cummings is acquitted on the merits of the case, the state cannot appeal. This is law. Let me bring in one more caller here before, and there was a question here for you, Mr. Councillor Verdier, before you went up. But let me take Ali Kamara. Ali, you are live. Quickly.
Yes, sir. Thank you so much for having me. Let me say hi to Councillor Jayweh, and I like to always call him my big brother, Jerome.
Your 1 minute will soon finish, Ali. So hurry up.
My 1 minute will not soon finish. You interrupted my 1 minute already. And to the beautiful, don't let me leave the lady out now. The beautiful
No,
But
you
I
didn't call
am,
the main hamster. That's how you'll get in trouble with you didn't call the main hamster, so don't call her beautiful. Go ahead.
no, I'm a heterosexual. What do you expect?
That's how you'll get in trouble.
But anyway, I like to say thanks. I always come to these programs to acquire knowledge, and which I have done. As someone who has absolutely no legal background, it only helps me to listen to people who have the background. I agree with the panelists that this case, I wouldn't say has no merit, but I would say this case does not have, it doesn't have much relevance in my opinion, and I don't think it should be a case of such magnitude. I think we should find a way to get rid of it. I believe within myself that Mr. Cummings will be acquitted, even though I am not a lawyer. But let me just say, Councilor Jayweh brings two things to the table. Not just the connotation or the denotation of the law, but he couples it with common sense. He is endowed with common sense. And I always say this to the ANC, if you listen to a guy like Councilor Jayweh, you help your side, because he comes with no prejudice, and he comes with speaking in the middle. I also want to remind ANC, I mean, being tough is good because you have to fight your right.
I knew you were going to this ANC and Unity Party thing, but go ahead.
No, I'm not going. I'm not. Not that you brought Unity Party. I may include Unity Party, but you know, the ANC must be aware that the victim here, no matter what they do, is going to be Alexander Cummings if they do piss the government off. I can guarantee them that I'm not a fan of the government. I despise the behavior of this government because they continue to deputate our people. But the more they get too intransigent and become arrogant against the government, the only thing that has power more than the government is God himself. These guys, like Councilor Jerome said, they can use the very articles in that Constitution. And Councilor Jayweh brought something to your attention, ANC. You should pay attention when he said that the Ministry of Justice is the only institution other than the Supreme Court that can actually try to verify somebody's nationality. They have the right to subpoena anything when it comes to somebody's citizenship. Okay, I'm not saying that Mr. Alexander Cummings is an American citizen. I'm saying I can tell you plain blank that once you were born in Liberia, you're a Liberian. However, they can use those numbers, those articles in the Constitution to go after Mr. Cummings. Mr. Cummings is the one who is going to be a serious victim in this matter. I think they should fight this case quietly, which I believe they might win this case. But the toe-to-toe fight and counter-argument and counter-insult with the government will only affect them and not the government. The government has the police, they have the military, they have the Supreme Court. You can't win them unless they want you to win them, especially the kind of government that we run. I also want to end with this note.
Please.
Now that you mentioned Unity Party. You know, Buckeye and some of the Unity Party hierarchy have been a little bit, not willing to participate in this thing that is going on.
You'll be subpoenaed.
But, well, even if they're subpoenaed, they are hesitant. It's clear that they're hesitant of being a part of it throughout. But what is going on now? We're waiting for what's going to happen tomorrow at the National Elections Commission. If it doesn't go Unity Party's way, before Unity Party was playing politics. If it doesn't go Unity Party's way, then it becomes personal. And again, they're going to Supreme Court, and who's going to be in the forefront again? It's Mr. Alexander Cummings. So I want to admonish our people, because regardless of the fact that we're on different sides of the political aisle, we're still brothers and sisters, and we're still Liberian. I still fight for your legal rights, but you have to understand ramifications as well. Everything that is legal is not necessarily expedient, like Councilor said. Thank you so much for having me.
Thank you. We have a lot there, and I want you to respond to all the callers, and then we're going to be wrapping this up. So let me start with Councilor Verdier. You had a question here from, I don't know if you heard from Evis.
Yeah, I remember it.
Okay.
Or I can just say, Liberian people should change the government.
Oh,
That's the best thing I can advise the Liberian people to do. They have tested, they have tried, they have seen, they have evaluated, they have expectations that were not fulfilled. They see the corruption, they see the disgrace, they see the airport that is dark, they see the healthcare system down, they see the education system down, people are dying here and there. Change the government.
Councillor, what does it have to do with the case we're talking about?
No, the question was about the TRC.
Yeah, and the TRC, what does that? You think changing
the
the
TRC
government
has not implemented.
Right, so changing the government, we changed government, it was still not implemented. So why changing this one is going to make it to be?
How do you know?
Because we changed from Ellen to we are, and we don't have it. First it was Ellen, now we are, and you are saying if we have a third government.
Well, let me tell you, Ellen reasons why she didn't implement it, and she ensured that George Weah came to power. We all know that George Weah signed an agreement with her. How do I know? I watch it on Ghana television. But he said Ellen needs to be protected, and that is the responsibility of his government to protect her and her family. That is why they haven't done any audits since they came there. And he is carrying on the mantra of not moving forward with the TRC. So I'm convinced that any of the full opposition leaders, Vice President Buckeye, Honorable Cummings, Councillor Tiawan Gonglo, or Mr. the guy from New Jersey who is under investigation, any of them, because they are professionals, they will listen to the Liberian people. They will do what the Liberian people expect of them. So we change the government. The TRC will be implemented. Thank you.
Thank you. Attorney Yeakula.
Yes, so the caller that said the ANC fighting the government, only Mr. Cummings will suffer. And yeah, we may be in the right, but it's not, we shouldn't fight too hard. I find that confusing because, you know, as a people and as a country, we don't know how to separate respect from accountability. You can respect someone, you can respect an institution, you can respect the government, and you can still hold that government, that person, or that institution accountable. And to expect that ANC partisans should not hold the government accountable for all of what it is doing, especially in regards to their standard bearer and a political leader, I think that's not just a confusing statement, but an unfair statement to make. I think what is even more interesting is the fact that a lot of Liberians who know and understand what is going on and choose to remain silent expect the ANC to also remain silent. The government is banking on the ANC silence to continue this persecution, because this is not a prosecution, it's a persecution of Mr. Cummings. And I can guarantee you the ANC will not remain silent. If this is why the Unity Party is silent, because they're afraid of offending the government, they're afraid of stepping up to the government, they're afraid of fighting the government, that's your party's decision to make. But at the ANC, we'll continue to hold this government accountable. We'll continue to call out the excesses of this government. We'll continue to call out the bad governance, the bad healthcare system, education, all of the things that are affecting the lives of the people. We and Mr. Cummings will continue to call it out, and they can bring everything they have at their disposal against them, and he will remain standing. On the issue of the UP being hesitant to be a part of this case, I would have preferred we stuck to the law and the legal issues that we're discussing. But the fact that the caller has brought in the politics, I think it's important that we address it, because for me, this is how misinformation continues. The Unity Party is not hesitant to be a part of this case. The Unity Party is an integral part of this case. And this is what the Liberian people needs to understand. The Unity Party is the puppet master behind this case. The Unity Party, in December, this case was brought against Mr. Cummings by the ALP officially in January. In December, specifically around December 20th, the Unity Party signed a resolution saying that the framework document was fraudulently altered by the ANC and Mr. Cummings, and so they were withdrawing from the CPP. That resolution was in December, long before ALP brought their case, long before ALP even released the statement. The Unity Party signed a resolution. Former President Joseph Boyka signed that resolution, saying that the framework document was fraudulently altered by Mr. Cummings in December. The Unity Party did that. Then December, the ALP released a statement saying that the framework document was fraudulently altered and they were considering legal options. ALP released that statement in December after Unity Party has signed the resolution. In January, ALP, through the national chairman, brought this bogus case against Mr. Cummings. Recently, the Unity Party withdrew from the CPP and wrote a letter to the NEC stating to the NEC that the framework document was fraudulently altered by Mr. Cummings and the ANC, and that's why they were withdrawing. That letter was never made public because Unity Party cannot stand by its words. So it was privately sent to the NEC. We do have a copy of that letter because as a member of the CPP, we have a right to get a copy of that letter. Unity Party did not inform the CPP it was withdrawing. Unity Party did not inform the CPP as to reasons why it was withdrawing. But Unity Party did not even inform the Liberian people that they were withdrawing because of alteration. They stated in their withdrawal message that Mr. Boyka read that the ANC was not cooperative, Mr. Cummings was not coming to meetings. At no point in that public statement did Ambassador Boyka or the UP say the framework document was fraudulently altered. But in their letter to NEC, they stated that the reason for the withdrawal was because the framework document was fraudulently altered. Yet this scholar wants the Liberian people to think that the Unity Party is hesitant to be a part. This is why the Unity Party has been silent, because they've been supporting the ALP to be the one to put their hand forward, and then the Unity Party will come as witnesses because Solicitor General has already said Ambassador Boyka, Mo Ali of the Unity Party will be his witnesses. This is a cahoot. This is a planned effort by the Unity Party and the ALP. So as much as this was about the law and discussing these legal issues, I'm sorry I had to address the politics of it because the Unity Party is not an innocent bystander here. The Unity Party is the puppet master.
And you got that word from Anthony Aloysius too, calling the ALP a puppet master. And from what you said, you also, I'm coming, Councillor Jayweh. From what you just said, you also disagree with Councillor Verdier, who said the ALP was a perceived innocent case of Verdier.
I disagreed, but the reason I didn't state my disagreement was because of the perceived. So he's correct. It's perceived to be an innocent case, but it's not innocent. So it's because he mentioned the perceived. So it's perceived.
And we're going to bring you back to talk the politics. We just wanted to do the law part today. So
I am available anytime.
All right, let's do.
Well, not anytime. My class schedule is crazy.
Yeah, no, we're gonna talk that offline. We're gonna talk that offline. So, Councillor Jayweh, you were saying something because we're about to close.
So
yeah, you had a time to respond.
I'm not going to go into the politics. I'm going to go into the case before the court. The complaint before the magistrate court is bordered or is captured under section 15.70 forgery. So whether Mr. Boyka did what, whether Yombli Kanga did what, whether
Yeakula
was being spoon-fed, doesn't matter to me at all. What matters to me is that it was forgery committed. And
alleged to have been committed.
I'm asking a question. I don't say alleged.
Oh, I thought you said it was forgery committed.
I'm not saying alleged. Okay. The question is, was forgery committed? That's a question that the court will have to answer when it's entering its own judgment. Okay. Anybody can say fraud was committed. Anybody can say this thing was forged. anybody could say that a crime was committed. The responsibility to establish that is on you. So again, I go back. Even if the magistrate court is now bringing Mr. Boakai to court, it's now bringing Yombi Kanga to court, it's now bringing Mr. Yeakula to court, they call him Bob Ben, bringing him to court. I, as a defense lawyer, will request the court to subpoena them because they have said things against my client for which they must come and prove. But if you don't do it, it's on you. If the court doesn't do it, it's on the defense. Mind you, this is a case that has to do with someone's reputation. And you must be able to defend him. Include bringing those who may have said fraud, may have said something different to the public, but written something different. They need to come to court, including the lawyers who basically said that they did the changes and that they committed themselves to conferences with the four political leaders. They need to come to court. If they don't come, you need to bring them. Subpoena will bring them.
Thank you.
What is the responsibility of the prosecution here, Councillor Jayweh?
Well, if again, I'm not prosecuting. If I'm prosecuting, I will bring those witnesses to on my rebuttal.
But isn't the burden is on the prosecution to prove, right? The allegations.
Right now, prosecution has an issue. There's an issue of documentation being extracted, and so the documentation, I presume, enough to acquit Mr. Cummings. If the prosecution should sit and allow that presumption to hold, then you are running a situation where at the end of the day, acquittal could be obtained because the slightest doubt in a criminal trial should work in the favor of the defense. My answer to you is that if I am prosecuting, I will bring those witnesses on and bring them as rebuttal witnesses. I will direct and redirect them.
Thank you so much, Councillor Jayweh. This Wednesday, as I told you, memorialization of the Liberian Civil War. I like to call it the Liberian on Civil War. What does the TRC recommend on the rewriting of Liberia's history and the use of wartime memories? My guest, Aaron Weah, he's a member of African Transitional Justice Network. He's a PhD researcher at Ulster University in the UK. He's going to be right here on Focus on Liberia, where we educate, we elevate, and promote all things Liberia. Remember now, today our topic was the Supreme Court. But I have no regret that we did not even touch it because we had some unfinished business to talk about.
Maybe nothing will come up next week.
Next week, join us for the Supreme Court. It will be right here. So at this time, again, Atty. Moriah Yeakula, Councillor Jerome Verdier, and Councillor Jayweh, thank you so much for coming. We miss Councillor Janet tonight, and Councillor Jayweh, please reach out. Let's see what's going on, and so we can have him back. At this time, we'll go around the room and say, give us your closing comment. Let's start with Councillor Jayweh this time.
Again, I will maintain that it is important for our people to stay the politics out, for our people to pay attention to what is going on. I maintain that they need to understand their rights so that not everything you run to a lawyer. If you know what happened before the courts, if you know the process of probating your deed, you wouldn't go pay $1,500 to a lawyer when it will cost you less than $300 to probate a deed. So it's a good thing that I will encourage them to pay attention to the legal process and pay attention to what happens in the court system. I think we have good laws. I think our problem is how we selectively enforce those laws. That's what the issues are. I am of the opinion that you want to prosecute all, not one.
Yeakula?
Yeah, thank you for having me, Dennis. And I mean, it's great being here. You know, this is one of my favorite things, discussing the law, politics too, but we can do that another time or another show. But I'm really happy that this show is really focused on discussing the law and legal issues in our country and helping our people understand how the legal system works, and even discussing some current cases. It's very essential and it's very important. And I hope it can get more people interested in it, because we all interested in the politics, we all interested in the news of the day, but when it comes to access to justice, when it comes to our justice system, our judiciary, we all complain about it, and rightly so. But it's also our responsibility to take advantage of the information that's available to us on this um, issue of the rule of law, of access to justice. I'm hoping we can provide more information to the people, as Councillor Jai said, on how to do certain simple things. I remember someone was saying at some point, um, you know, lawyers will always be needed, but simple things that require just forms, that people can do on their own. They may not have to need lawyers for it, and just knowing how they can navigate the legal system to get these things done. Again, Liberia is supposed to be a country of laws and not men. Unfortunately, we have a few men today who are laws upon themselves and decide who they can use the law and the loopholes in the laws to go after. And selective justice is the order of the day. And we hope at some point we can all get this right. Take a 360 and ensure that our country becomes what it should be. So thank you for having me, and I look forward to the next discussion, so hopefully on the Supreme Court.
Thank you so much. Councillor Verdier, your closing comments, sir.
Yes, sir. We're going to thank God for affording us the opportunity to be here. I was glad to appear and share the platform with my distinguished colleagues. We intended to break the ice, but we crushed the ice. But nothing is lost. What our discussion brought to light is that the governance structure, which is the political structure in Liberia, is predatory and suppressive. Any opportunity that government officials have to take away from the people, to steal, to corrupt, or to deprive the people of their rights, the government goes that way. From history, when it came to paying taxes, our people were beaten, they were jailed, they were suppressed, but yet government collects all the taxes, excuse me, and doesn't use the taxes for the good of the people. That's where it is predatory. It is suppressive when it steals all of the resources and give nothing to the people. They take away the people's rights, takes away the people's voice, and it deprives the people of development. That's bad governance. Those are the things that we are campaigning against, and we hope the new Liberia will put away. And I emphasize, if a prominent and honorable citizen, as Mr. Cummings, can be treated in the manner in which he was treated, and as we discussed, what do you think of the ordinary man who has no name, has no career, has no power, is at the mercy of the government? You see what is going on now? The government wants Atty to give them $30 million for a campaign. Atty said, extend the agreement, and I will give you $1 million for each year. It doesn't matter to the government whether or not Atty has performed in the previous agreement, but they want to expand it because they want 25 million. to use to influence the elections. You keep the people hungry. You deprive them of everything. And then you see election time, we give them lunches. We give them money. And then they will vote for us. That's the kind of mentality, the culture, and the nature of politics in Liberia that has to be changed. Thank you. It was good to be here. I will come begin God's willing next Sunday. And the platform was well shared with our distinguished colleagues.
And I want to say thanks to all of you. Also want to thank our audience watching now and even those who will watch later. Continue to tune in to Focus on Liberia, where we educate, we elevate, and promote all things Liberia. On that note, we're going to close the broadcast, but not until we play the songs that says we are all Liberians. Whether you think Mr. Cummings is innocent in this case, or he actually changed the document, we are all Liberians. Whatever your opinion may be concerning the court system in our country, we are all Liberians. What is incumbent upon us, though, is to do whatever it takes to make our country the glorious land of liberty. Have a good night, and God bless you.
We are Liberians.